Matt Reardon. Mr. Reardon, I'm going to give you a warning one time only. The next time you call up here, the next time you give anybody in my staff a hard time, I'm going to have you arrested for contempt of court. You're not to come up here. When you call up here, you have to be corrected.
Your Honor, how did I do that?
Be quiet, sir. I hear you saying you want to discuss something with me. Let's hear it. What do you want to discuss with me?
I was simply trying to inquire on the outcome of my ex. She falsely accused me of rape. You've created a monster.
Please take him on back. Take him on back to the back. Go back, sir. I'm going to hold you in contempt of court. Take him on back.
Your Honor, I was just trying to address this.
All right, sir, let's go. Come on. You want to go on your own?
Go on back.
Your Honor, please. My wife is outside. My wife is outside. My wife is outside. So which one?
I reviewed your motion to dismiss on the alternative transfer, but you are entitled to hear on that. I think just a couple thoughts on it. This is your initial appearance, whether you plead guilty or not guilty, obviously, by looking at your motion or by viewing your motion in your dismissal of the alternative transfer that you are obviously pleaded not guilty, so I don't know that I even need to ask you that, but I do want to rule on the motion. Anytime a motion is filed, a pretrial motion is filed, I always like to get those done in advance, because it's bad if you show up on the court, the actual day that you have the trial, and if those motions are denied or granted, then sometimes it's not even necessary to have a court date.
It's the story of my life. I've had 3 other courts that I haven't gotten any kind of rulings on my motions, and apparently, Your Honor, because I don't have a bar number, I don't get taken very seriously.
Well, I mean, it's again, you filed in the proper form. You did get it filed, and that's all you have to do here. You filed a written motion. I've reviewed all the allegations that you have. It kind of speaks for itself. It was a very lengthy motion, so I don't know if there's anything else you want to add to it. I would say that what I'm going to do is I'm going to deny your motion at this time, as I do all. It doesn't mean that it will be finally denied. You can certainly feel free, and you may know this already, to renew your motion once we have a hearing date on this, trial date. This is merely your initial appearance date. I'm going to deny your motion at this time for dismissal, and we're going to trial, and I'm going to give you a date. This is for a remote hearing, just like we're doing now. We're trying to keep everyone safe. You got counter claim here. I'm going to dismiss that. Deny your motion, dismiss at this point. Obviously, you can renew that motion again on the trial date, and we're going to give you a Zoom trial date. We're trying to set these trial dates on a date that where you don't have to wait, as we did today from the middle of the date and court date, and it's a date and time. So hold on just 1 second.
Okay. Your Honor, if I may, how can I ever get a fair trial without a jury in municipal court? It being the particular type of accusation.
Hold on just 1 second. It's January 14th at I'll do it at 1 o'clock. We're going to mail you continuous that. I didn't mean to interrupt you, Mr. Reardon. It's going to be January 14th at 1 o'clock. It'll be a Zoom hearing. We'll have the attorney here. I'll hear your argument. I'll look at your motion to dismiss again, and again we'll take it from there. I know you're familiar with the court system. You said you've been in some other courts, so you kind of know how it works. I don't really have an answer for you if you feel like you're not getting a fair shake on it. But we don't have juries here. They have juries in justice court, but you're not entitled. No one's entitled to a jury.
Your Honor, that's why the whole in the alternative to transfer, I'm wanting to move this to circuit court in order to get a fair trial via a jury of my peers, and I find it highly prejudicial highly prejudicial and even offensive, constitutionally offensive, to have to stand trial before my accuser as my jury.
And I do take note of that point, and I did see that you had that motion to transfer in there as well. So I'm going to deny that motion to transfer. Again, I will transfer cases if the law says, if I believe that they need to be transferred, I can do that to justice court. But in this case, at this time, I'm not transferring it. And I will take note of your remarks. Again, you feel free to make the same arguments again if you need to, or if you feel like you want to on this other day. And you've always got, whatever decision I make, if it's a fine, I'm guilty, obviously you always have the right to appeal my decision to the county court of DeSoto County, and then that you are entitled, according to the judge, you may be entitled rather to a 6-person jury to hear your arguments at that point, or to hear your case at that point. So
that's what
it'll be a Zoom court meeting.
Yeah, I'm going to go ahead and I'm going to go ahead and I'm going to appeal it though, because I feel like it's just dragging it out. It doesn't need to get drug out all this time. And I can't, Your Honor, you know as well as I do, I can't get a fair hearing in front of the accuser, that is presiding over the case.
Well, again, you can make those arguments, obviously, and if you, whatever appeal, steps you need to take, you can certainly do that. That's up to you. But as I said, I'm overruling your motion at this point, and I'm dismissing your counterclaim because of lack of jurisdiction. And we'll send an order out to you, a formal order in writing. It tells exactly what I did, where you'll have it. And then again, you can take whatever steps that you feel like you need to between now and your next court date.
Okay, Your Honor. One other thing, I've asked on 3 separate occasions for a simple, complaint, criminal complaint or a civil complaint. I don't know if this is civil or criminal. I've yet to be served anything, and I've asked now 3 separate occasions for a crime bill, just simply a complaint to be sent to me, to be able to read the affidavit, read the crime, and in all 3 they've been ignored.
Well, are you saying that you don't have a copy of the affidavit yet?
I don't have a copy of the affidavit, no.
Okay, we can get that to you. Your prosecutor, you've requested discovery. Of course, the rules state he's got 30 days to respond to you, but he's going to be doing that and responding to the discovery. He's the one handling your case, and I understand what you're stating, and I'll make a note here of your request again verbally, even though I think you've requested it before, you said. So we'll have a response to you certainly before the court date, and we will see you on that court date.
All right.
Thank you.
Thanks.
Mayor Phillips, Mr. Dye. As a prior resident of Olive Branch, and the love for Olive Branch that my small family did share, it pains me to be typing this letter to you. Yesterday, on the 19th, I dealt with the most abominable, putrid of dealings and treatment by your municipal judge, Leslie Shoemate. That in itself is an upgrade for the complete lawlessness, lack of moral turpitude and integrity, and sharp, hard turn away from the Constitution and expectations of a functioning society. This type of reprehensible behavior by any government employee should never be tolerated. Yet it's become a common reality that I've witnessed more and more over the past several years, and especially when I decided to embark on my inner calling to document and produce in the live, ongoing documentary series, Riding with the Outlaw. I am a Marine Corps veteran. I swore an oath to my country to uphold and defend its Constitution against all enemies, both foreign and domestic. In the clear, cutthroat attack by this lawless municipal court judge in Olive Branch today pretty much undercut everything that I've seen and documented. There's an extreme abuse and fissuring of the judicial gavel, a permanent staining of the robe in which he wears, most certainly a tipping of the judicial scales, and a sharp declaration of war on our blended constitutional republic / democracy. The founding fathers of America, who declared our independence, are rolling over and over in their graves. The same ones whom outlined and emboldened our basic human rights of life, liberty, and the pursuit of happiness, and composed our Constitution, which has been the foundation that has set and molded America as the last truly free nation in the world, governed by laws meant to extend to all individuals and especially to protect all, especially naturalized citizens. In my time of dedicating myself to my country, and in my 33 years, I know of one Constitution, one set of laws, not two. This judge is not above the law. He's not above the Constitution. And the treacherous mistake that he just made yesterday is definitely going to cost Olive Branch. Judge Shoemate is a danger and a liability to the city of Olive Branch. He is a tarnish on the good name. I trust to it that Mr. Mayor and Mr. Dye will see to it that Judge Shoemate is relieved of his duties as municipal court judge of Olive Branch by the end of the day tomorrow. Watch this video. See the proof. See that I did nothing to deserve the consequences that I reaped yesterday. All I've asked since the beginning were for equal protection of the laws, for the laws to be applied evenly. And I don't think I'm asking too much. My name is Matt Reardon, and I am the Oxford Outlaw.
This call may be monitored or recorded for quality assurance purposes.
Hello?
Hey.
Hey. I don't want to fight with you. You know, this is what I did, you know, out of, hey, let's just have some peace.
Well, and I mean,
I didn't tell you because it was one of those, you don't let the left hand know what the right hand is doing.
I understand, and you need to understand that if I wanted to fight, if I wanted hate, I mean, do you not think I had every opportunity under the sun? As long as
and I'm pretty sure of that. I'm pretty sure of that, Matthew, and that is something that I also considered. I know that you can fight your own battles, and I know that you will.
I mean, that's why, despite through it all, I mean, I've been far from an unreasonable person, despite all the shit that I've had to deal with over the last 3 years.
I know that, Matt, and that makes two of us. But
I think what I had to deal with was a little bit more serious.
Well, potato, potato, tomato, tomato.
No, it was a certain huge difference, because had the circumstances have been different, and had I been living in Oxford, I would have been guilty until proven innocent, and I probably would have been fucking shanked for the accusation that was put against me. Definitely the first one, and quite possibly the second.
Matt, again, there are things that you and I both have to take to the cross. And I know for a fact that there are things that I have definitely taken to the cross and have left there. And it is pure evil and hatred for me to be subjected to everything brought up over and over again.
I just never did confront it. You and I never did actually talk about that. I have no idea why that happened. I can only assume it was probably Dustin, and played a part in it.
That was a major part, yes. Again, there are things that we have to take to the cross, Matt, and leave it there. Matt, nobody is perfect.
Hey, Maddie's calling. Let me get this.
Okay.
All right.
All right.
Bye.
Hey, what do you think? Now we got it on you. And what's your name? Amy? How old are you, Amy? 6. How many sisters do you have? You 2? Have you already forgotten Lydia? How long has it been since you've seen Lydia? You don't know? Hey, you seen her at school? Hey baby, lay the other way. You don't wanna, hey, you never wanna be laying with your legs spread towards anybody or on camera. You miss Lydia? What all did you and Lydia used to do together? Played. What was your funnest thing whenever she came over? And when y'all had the phone, make silly recordings? Yeah. Your mom and I heard those. Those were pretty funny. I don't know if you knew. Y'all were recording little bits and pieces. There's Matt Reardon, Manic Mobile. Lydia's on the radio. Hopefully you get to see her tomorrow. I know all of y'all miss her tremendously.
Afternoon, U.S. Attorney's Office.
Yes, ma'am. I'm trying to figure out who I need to speak with. Who oversees y'all's department?
It's the Department of Justice, is that what you're asking?
Yes. Okay. Would I need to contact Jackson, or I'm trying to? I feel like y'all's main job is not being done at all. I mean, I'm a citizen of the state of Mississippi. I was framed in what I think is the largest public corruption scandal. It involves people in the local government in Oxford. I've been calling now for 2 weeks. I've been leaving messages. I got a call that I missed last Friday, and I left a message, a voicemail 2 days ago. I don't know what could be more important. Like, in 2 weeks' time, not getting one phone call. Go to the U.S. Attorney's Office, and something this big, somebody should have reached out to me by now.
Okay, one moment. I'm unable to assist you in this situation because I'm not exactly sure what's going on. But I'm going to transfer you to someone who can hopefully help you.
I hope I can speak to somebody finally.
This is Robin. Sorry I'm away from my phone right now. If you'd leave a message, I will call you back as soon as possible. Thank you.
Robin, this is Matt Reardon. I left you a message 2-3 days ago now. I've been calling up there for about the past 2 weeks in regards to what I think is quite likely one of the largest public corruption scandals in the state of Mississippi. And I can't even get the U.S. Attorney's Office to give me a call back. It's a damn shame. So clearly I'm probably just going to have to go this route on my own. I take it that just not even getting a call back, the U.S. Attorney's Office is not interested in investigating this, much less hearing about it. So, if you're in the office today, please give me a call back, 662-892-0132. I gotta be honest with you, it really, really bothers me because the agency's tasked with protecting the American people through not even responding, do not even help, are hurting the American citizens. And I'd like to think that that's not what's going on up there, but 2 weeks' time, and I've stressed the importance of this, my time is running out. The statute of limitations is running out. Please give me a call, 662-892-0132. Thank you.
Hey, you gotta move that.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more time.
I'm here at the sheriff's department.
Move, or you will go to jail for disorderly.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop!
In the Justice Court of Lafayette County, Mississippi. Lafayette County, in the state of Mississippi versus Matthew Reardon. This is the defendant's motion to dismiss or transfer in regards to disorderly conduct and resisting arrest. Comes now, Matthew Reardon, your defendant. and brings his motion for dismissal or in the alternative to transfer venue to an alternative jurisdiction outside of Lafayette County, Mississippi, else defendant hereby gives notice of his intention to immediately petition the U.S. District Court for the Northern District of Mississippi for emergency injunctive relief and the determination of jurisdiction in this cause due to all reasons of prejudice and biasness, which the plaintiff in this matter is well aware of and shouldn't need to be reminded. Without waiving any of his rights, defendant Movant hereby enters his plea of not guilty and hereby gives his answer. 1. Movant asserts that this complaint stemmed from what easily appears to show that defendant was retaliated upon by Deputy Courtney Dixon, who knew and had issues with the defendant prior due to his filming of a documentary called Riding with the Outlaw in an effort to seek vindication and justice for the criminal acts aggrieved upon him. Deputy Dixon is seen during one of the defendant's more recent video releases, approximately 2 months prior, threatening defendant with arrest and further fishing for irrelevant information in order to try to arrest defendant for some reason or another. This all ends with Dixon asking another deputy if he would like to write up a report on the defendant simply for defendant being at Sheriff's Department conducting an independent investigation and trying to ascertain answers to a particular grievance as to why Major Alan Wilburn would not produce evidence to an untrue, libelous, and defaming statement he gave to the Oxford Eagle on May 30th, 2017. Regardless of the matter, defendant had every right to be at the Sheriff's Department and to ask questions. The plaintiff has absolutely no right to threaten or restrict the liberties of another over personal views, especially when that individual is trying to ascertain answers which are part of a currently ongoing litigation. This particular occurrence is shown in the release Patriotic Pushback, beginning right after the narrative on the homepage of MattReardon.com, and defendant will list that as Exhibit A. Number 2, that on December 27, 2020, defendant had emailed Sheriff Joey East in an effort to get the Sheriff of Lafayette County to enforce the laws evenly and equally, further extending to defendant, among others, the equal protections of the laws as guaranteed by the 14th Amendment to the United States Constitution and further guaranteed by Article 3, Sections 8, 11, 13, 24, 26A, and 32 of the Mississippi Bill of Rights, a major part of its Constitution, and the rights of all citizens. Defendant in this cause continued to be victimized by acts of criminal conspiracy and organized crime by way of his ex-girlfriend and mother of his child, Phyllis Liz Crowder, her attorneys, and certain other John and Jane Does. None of this mattered to this department, nor this county, as defendant in this cause was the victim. Defendant asserts due to ongoing litigation and the fact that Lafayette County amassed such massive liability on itself from 2 prior conspired upon false arrests on defendant, which defendant had gathered indisputable evidence on, it was not going to provide defendant with equal protections, and it in fact has been complicit in the ongoing criminality. Lafayette County Sheriff Joey East read but did not respond to the email of defendant's grievance in seeking assistance of law enforcement to deter such major issues stemming from the criminal conspiracy of his ex. Email attached as Exhibit B. 3. It was the following day, December 28, 2020, that defendant drove to Lafayette County Sheriff's Office to await the sheriff in order to confront him in person so as to attempt to compel the assistance of the sheriff, as it is the Lafayette County jurisdiction in which the major issue stems. Defendant parked next to Sheriff Joey East's vehicle and awaited the sheriff outside so he could obtain some type of answer from the sheriff, a publicly elected position in which providing answers should be an obligation that most certainly is backed by the protections of the defendant's First Amendment rights to petition the government for a redress of grievances. Soon after, Deputy Dixon came out with Deputy Omar Ahmed. Dixon told defendant to move his car, to which defendant replied he would happily do so once he spoke with the sheriff. At this point, it was clear the sheriff was intentionally avoiding him. The deputy then said defendant had to move it now or be arrested for disorderly conduct. Defendant simply tried to ask how awaiting the sheriff could be considered disorderly conduct while in the process of moving his car to another spot, when this off-tilt, completely perturbed sheriff deputy told defendant he was under arrest and proceeded to grabbing defendant and throwing him on the ground using extremely excessive force, clearly demonstrating his dislike of defendant and the way he used extremely excessive force in the way he made his arrest. In the process, defendant's head was struck against the ground, along with his cell phone being thrown. It is the impression of defendant that this was done in an effort to damage or destroy evidence, although defendant can't make such claim with 100% certainty without seeing the video recordings from the outdoor camera. By this time, the sheriff was outside, just watching like a spectator would watch a sports game. Defendant never resisted arrest, even though Mississippi is one of the few states that actually allows the resisting of an unlawful, undeserving, and unconstitutional arrest, which defendant states in assurance is exactly what this was. Defendant was then restrained for upwards of at least an hour in a restraint chair with his hands tied uncomfortably behind the chair while jailers and inmates watched. The sheriff still refused to talk to defendant about his grievances. 4. Defendant received a bond amount of $500 the next day. Defendant and his spouse arranged for bond to be paid, and upon the bonding agent and defendant's spouse arriving between the hours of 5 p.m. and 6 p.m., they were turned away after being told Lafayette County Sheriff Joey East was invoking some special authority to personally sign off on defendant's bond, and would do so the next day after he personally spoke with the defendant. The sheriff waited until the afternoon on the 30th of December before pulling the defendant into a room and discussing with him his tactics and assertiveness in a courtroom, and in the way he sought justice and vindication, classifying it as wrong when it was this very department, along with the malice acts of the district attorney's office, that outrageously destroyed the rights and life of defendant just 3 years prior. Once again used fear and arrest as a tactic in their arsenal to try to sway a favorable outcome. Defendant asserts this amounts to false arrest and unlawful detention, among others, wherefore all premises considered. Defendant requests this cause be immediately dismissed, or in the alternative to be transferred due to the grievances stated within. Otherwise, defendant counterclaims in the amount of $5 million in damages, thus making the jurisdiction
the Oxford Outlaw. I wanted to go ahead and I wanted to cap up what all just happened, what all just took place. Nothing really that big. In fact, I already put out an article about this. Had court at Justice Court in Lafayette County in front of the Honorable Mickey Avent, and I do truly mean that. He's one of the, I'll say he's probably the only straight judge that Lafayette County has when it comes to Justice Court. He's by the book. And that's the only reason why I decided I would go ahead and I would keep it in Lafayette County. I would fight it in Lafayette County. Judge Avent told me last week, he started reading my motion that I submitted. Hell, by now he's probably seen the video. He told me because he was the judge on the case and he saw that it started spilling into the details, he stopped reading it right there. So there was no, in advance dismissing. Lafayette County is in fact not dismissing the charges. So I am in fact I'm giving Mickey Avent the benefit of the doubt here. I'm gonna let him try it because I think he can. Although I think that there are certainly a lot of conflicts of interest here in the area. I think that Mickey's going to look at the facts. And I think that regardless, I think that he would weigh it evenly. And I think regardless, he's going to come to the same opinion that I did. That in no way, shape, or form did anything that I did truly constitute an arrest by Courtney Dixon. Horrible state actor. Omar Ahmed, right there with him. Horrible. What was funny is, looking back at the police reports back from 2015, I was arrested for family disturbance by none other than Omar Ahmed and his partner, Courtney Dixon. Isn't it funny that they roll together even today? Joey East refused to speak to me. He watched like it was a spectator sport while they were trying to beat my ass in the parking lot. Well, I got news. $5 million counterclaim against Lafayette County. I'm getting it filed. Motion discovery and subpoena ducis tecum getting issued today. It's been a crazy last 6 months, technically about 9, since I came back here to Oxford to get to the bottom of everything. And since I got back, crazy is an understatement. By now, I think I've sent the message that I'm not scared and I'm not back down. I'm not going anywhere. See, I was talking about the other day, there's so many ironic similarities to 2017, everything that happened in 2017. If you really start piecing it together, everything, and I mean everything, lines up. Liz Crowder, unfairly, just out of the blue, 2017 kicked everything off when she took my daughter, kept her held hostage away from me. You have the sheriff's department that made a stupid arrest for disorderly conduct that really set everything in motion. You look at today, you had another stupid arrest by the sheriff's department for disorderly conduct. And they tagged resisting arrest in as a little added icing on the cake for them. They added in Olive Branch with a crooked judge over there when I was already victimized. But there's one thing different in 2020 and 2021. First being, I've spanned this thing out a lot longer. This is a quick, what they did 3 years ago was quickly thrown together without much preparation. What I'm doing now is 100% methodical. I'm premonition. I see what they're doing. I'm 3 moves ahead, but they weren't ready for me to take the battle straight to them. James O'Keefe just put out a message about exposing big tech. We can't forget to expose corrupt state actors, and that's what I'm doing. Check out MattReardon.com.
In the Circuit Court of Lafayette County, Mississippi, Matthew Oliver Reardon versus State of Mississippi, cause number L20-316. This is a motion for relief from judgment or order. Comes now before the court, Matthew Reardon, the petitioner and plaintiff, and respectfully moves this court for relief from judgment on cause number L20-316. Petitioner would show just cause through the upcoming reasons listed. Showing to the court the following reasons Movan is entitled to relief. Fraud committed on behalf of Lafayette County officials and employees. A. NLRCP Rule 5.1b3 states if a person is taken into custody, the person shall be taken without unnecessary delay, and in no event later than 48 hours after arrest before a judge who shall proceed with an initial appearance. The aforementioned cited rule goes on to state, if the person arrested is not taken before a judge within 48 hours, the person detained shall be released on execution of an appearance bond in the minimum amount set pursuant to Rule 8 and directed to appear at a specified time and place. Rule 5.1b3 conforms to the United States Supreme Court holdings in Gerstein v. Pugh. 2. 2, that petitioner Movan was deprived of due process rights guaranteed to him by both state and federal law. Petitioner was unlawfully confined at the Lafayette County Detention Center for 6 weeks' time. Petitioner was denied the opportunity to obtain a lower bond amount that fell within reasonable guidelines which petitioner or his family could afford. Movan was held on a bond set 3 times higher than guidelines allow, despite the state of Mississippi not producing so much as a piece of evidence suggesting it had a valid claim. Petitioner in this cause asserted he had evidence to prove he couldn't have committed such a crime alleged, petitioner never being accused of a felonious crime prior, and absolutely no injuries inflicted upon the claimant. A habeas corpus petition was filed by the public defender commanding the sheriff of Lafayette County to bring petitioner before the court to show just cause for the illegal confinement of the petition. And while the petition approved to proceed via informa pauperis, petitioner was never brought before the court and was further illegally confined for an additional 4 weeks' time. Petitioner was never made aware of this habeas petition ever being filed until nearly 6 months later, when he found out on his own. This amounts to misrepresentation by petitioner's counsel, and petitioner has been requesting answers to no avail, making the petitioner question whether fraud had occurred, yet unsure where the true liability and responsibility falls. Due process rights entitle the defendant in a cause to receive a preliminary hearing to determine if there is enough evidence warranting the defendant to stand trial. Petitioner was never afforded a preliminary trial within 14 days as required by law, which in the absence of a preliminary hearing within 14 days requires that the defendant be released on his own personal recognizance and be given a court date and time. This never happened. All requests by petitioner to have his bond lowered to a constitutionally fit amount went completely ignored after being given a bond amount that was 3 times higher than the maximum guidelines established less than a year prior by the Mississippi Supreme Court. That established guidelines called for an alleged crime punishable by a maximum up to 10 years incarceration to be set in the range of $5,000 to $50,000. Petitioner's alleged crime, yada yada. The crime Movan was accused of included a maximum fine of $3,000 and a maximum incarceration of 5 years. The bond set in this case was nowhere in the vicinity of established guidelines set by the Mississippi Supreme Court. Movan petitioner never caused any physical harm to anyone, had never been accused of a felony crime prior to this allegation. Bond is not supposed to be set in a punitive way, only to ensure the defendant shows up to appearances. Movan/petitioner had pending ongoing litigation against Lafayette County due to a highly contestable arrest made on May 1st, 2017, when Movan was arrested for disorderly conduct, simply for standing on public property holding the then state flag of Mississippi. Movan states that it is this reason, along with his child and girlfriend at the time, which would have easily shown and conveyed the fact that Movan was not a flight risk, not to mention Movan is a Marine Corps veteran that had never had a prior history of being a flight risk. Therefore, it is entirely the impression of the Movan that bond was used in a punitive way by a Justice Court Judge, Carolyn Bell, that has had a history of setting bonds in the lower end of bond guidelines. Movan petitioner was held, restricted, suppressed, and illegally confined in the Lafayette County Detention Center from the time of his arrest on May 26, 2017 until he received an initial bond hearing on May 30th. This amounted to nearly 96 hours before Movan was brought before a judge. This was twice the maximum length allowable under Mississippi Rules of Criminal Procedure, which was readopted less than a year prior. Movan was not only denied a reasonable bond for Lafayette County's egregious errors, but Justice Court Judge Carolyn Bell's bond issued appearance bond of $150,000 for a presumably innocent American by long-standing court precedents showed bond being used in a punitive way to influence the outcome of a sham legal proceeding, which was initiated by Lafayette County in the state of Mississippi, its employees, along with elected and appointed officials under knowingly false pretenses. The fact that Movan was interrupted by Judge Bell and advised of his Fifth Amendment rights on 2 separate occasions when he tried to show information up front, which would show the impossibility of Movan to have committed the alleged crime, should concern and frighten every American. Petitioner asserts incomplete confidence what all concluding evidence would demonstrate as a clearly shown political attack on petitioner by way of criminal conspiracy, racketeering, organized crime, and the successful deprivation and continued deprivation of the petitioner's rights. Petitioner Movan states that his life was completely ruined and millions of splinters sent ripping through the area and surrounded area.
to the Mississippi Supreme Court. Pursuant to Rule 5 of the Mississippi Rules for Appellate Procedure, Matthew Reardon, the respondent and defendant in the above captioned cause, files his petition for permission to interlocutory appeal to the Mississippi Supreme Court. Movant states that this petition is filed in good timing and most certainly with good merit, based on grounds for which relief through an interlocutory appeal may be sought. Movant would affirm that he has continued to sustain repetitive injuries at the baseless, frivolous, and vindictive hands of the petitioner's legal counsel, along with the state of Mississippi. Movant states that each motion brought before this court has been prejudicially ignored, with preferential treatment shown to the petitioner in this cause the entire time, despite the fact that petitioners had a history of filing false reports, and this very cause will show the furtherance of petitioner's continued behavior, which is not only morally incomprehensible, but in fact rises to the level of criminal conduct by flagrant and uncaring violations of Mississippi Annotated Code 97-7-10, fraudulent statements and representations, along with Mississippi Annotated Code 97-1-1, conspiracy, which the state of Mississippi has refused to acknowledge, condemn, and deter, despite petitioner meeting literally every criteria of the statute needed for an indictment by a grand jury. Yet through what would easily appear to be culpable negligence at the hands of state actors acting under color of law, she has continued to get away with the intentional infliction of injuries upon the respondent and movant, and this court is further feeding into it by immorally changing a standing order when absolutely no evidence was produced and court proceedings delayed. Movant further demonstrates the preferential treatment shown through his filing of a motion to dismiss or in the alternative to transfer venue, filed 11/16/2020, on the basis that venue, while jurisdictionally is proper, is in fact improper at the Chancery Court of Lafayette County, Mississippi, due to reasons of constitutional law, equity sought in counterclaims by the respondent due to the injury sustained, zero evidence produced up front, as a way of justifying 9 months of contempt in violating a visitation order and a jury demand by the respondent movant for these reasons stated, and stray away from the constitutional norm and lack of acknowledgement by this court on any of the motions or petitions filed with this court. Motion is attached to this filing as Exhibit A. It would most certainly appear that any response or forward motion brought by movant is destined to fall upon blind eyes and deaf ears, despite all evidence almost certainly warranting the dismissal of petitioner's cause. Petitioner, along with the court, moved on their own to enter an order of supervised visitation and appointment of guardian ad litem, which was drafted by the petitioner's attorney, accepted, signed by the judge, and filed by this court unsigned by the movant, despite his motion to dismiss or transfer being opened and unanswered and ignored by this court. Order filed a judge without movant signatures attached as Exhibit B. Despite serious issues of law, ethics, and criminal wrongdoing raised and alleged, none of this mattered. It is entirely the opinion of the movant that influence, along with ongoing pending litigation over extreme civil rights violations committed through officials of Lafayette County, have indeed created what movant cites as a constitutional crisis by way of trying to fix a desirable outcome through the initiation of legal proceedings, frivolous and undeserving, done with ill intention, and further using the pressure of keeping movant's minor child from him to make him cave on a matter. This was precisely the case in May of 2017, and movant has been consistent in stating the same claims about how his minor child was used as a manipulation tool of the courts by the minor child's mother for her own personal gain, whom by ways of collusion and criminal conspiracy plotted and in many ways were successful in eliminating and reducing the legal liability stemming from the actions of certain individuals and officials in Lafayette County, Mississippi, whom will be named in a separate court filing. The fact that this court allows her to carry on despite her claims raised as complete lies in light of her having a history of pathological lying through the false reporting of crimes is an absolute shame, and one that should question the validity of other rulings or if this is simply isolated. While movant has continued to gain more legal knowledge, especially in the composing of briefs, motions, petitions, and responses, which most certainly will fare to his advantage in the future as an attorney should he choose to pursue that, true justice is nowhere in sight. Movan asserts and affirms through multiple recent examples, including this cause, that there's been a clearly shown lack of adherence and care to the equal protections under the laws which are afforded to all citizens under the 14th Amendment to the United States Constitution, a system designed to provide due process and one that should stay uninfluenceable and non-biased, would appear to have drifted away from acceptable norms that would gain and keep the trust of citizens now is clouded with uncertainty. All appearances of influence controlled and, quite frankly, has gone on tilt, continuously spiraling further and further out of control. The first question Movent would pose is, what good are laws, and why were laws instituted if they can be so bludgeoned and blatantly abused, even when such abuse is brought to the attention of those tasked with upholding and enforcing such laws? Does the state of Mississippi actually condone this type of behavior? And even more so, do they condone the culpably negligent actors whom are fully aware of it and allow the continuation of such, despite the damage continually inflicted by the victim, whom has exhausted remedies and seeking immediate relief from the government, whom is tasked with protecting its citizens by way of providing equal protections under its laws? Our country has operated under the policy in name of innocent until proven guilty in a court of law. I say in name because it's something that exists clearly just to sound good and give off false hope to anyone suffering at the hands of a completely flawed criminal justice system, when in fact all too often the accused are looked at and treated as guilty until they prove their innocence. That fact is made blatantly clear in this cause, and it couldn't be any clearer. After 2 scheduled hearings, the petitioner has not produced one single strand of evidence which would even suggest that she has a valid, non-frivolous claim. And in fact, every motion and response filed by respondent/Movin has stated, in fact, very serious claims of petitioner having a history of making false reports, and that Movin was advised multiple times that petitioner was lying through her teeth, and that they would never assert anything of the such which petitioner has asserted now on 3 separately filed documents filed with this court under signed and sworn affidavit. Has this court even one time considered an obvious, most certain guarantee that law enforcement would have been involved had any of the petitioner's claims been true? There would have been some report by the proper agency and authorities brought before this court and shown up front as grounds to keep a father from his scheduled normal visitation with his child for 10 months. Even more concerning is the fact that Movent was barred from even seeing his child by the petitioner in this cause, despite her being in receipt of $600 of child support paid every month, further grieving financial hardship on the Movent's now family of 5 due to the amount being far outside of allowable guidelines.
Okay, it's Matt Reardon, the Oxford Outlaw. I'm back with another filing, something signature here with Writing with the Outlaw that I've begun to do a lot of. In fact, I've done just about every single filing that I've made. I've released a video of actually reading the filing, because a lot of people don't like to just sit there and read stuff, okay? This is a very interesting filing, and honestly, I'm not even through with it yet. I just wanted to go ahead and I wanted to release a piece of it. This stems from 4 subpoenas being sent out by Liz Crowder, by her attorney, Mona Pittman. In regards to the family court case, they are trying to basically jack my daughter out of my life, undeservingly. And this is all from Liz making false filings. This particular cause stems from Olive Branch Police Department picking Liz up on a warrant for filing a false report of rape back in November of 2018. They picked her up in January of this year. The warrant was cut back in, I think, January of 2019, and go figure, Lafayette County Sheriff's Department never picked her up in a year's time. She was arrested, she was taken in on this warrant in January of 2020, and since then I have not seen my daughter Lydia. There's court-ordered visitation in place where I'm supposed to get her every other weekend, like 5 in the afternoon until Sunday evening, and then the normal other visitation that comes with it. Haven't seen my daughter in a year. Over a year. I don't have an attorney. Quite frankly, I can't afford an attorney. All the mess that I'm dealing with right now, the fight with riding with the outlaw, I've yet to collect a single donation. I don't have an attorney representing me on any of that, and I've actually been making all my filings aggressively, fighting this fight on my own. I've probably filed over 300 pages of court documents over 2 to 3 months' time. I am now in 2 Supreme Court appeals. I've got a federal lawsuit filed against the city of Olive Branch and the state of Mississippi for the unlawful arrest that was made in regards to the false rape accusation, where the corrupt judge let her off with no jail time so long as she paid the fine in full, which benefited the city of Olive Branch 100% at the complete demise of the victim, myself. And also knowing that my child support money that is held out of my income went to pay to keep her out of jail while she is continuing to keep my child from me. Probably telling my daughter the most heinous of lies, especially being that she can lie to the court the way that she does. So anyways, after it looks like everything fell through for them, they filed a fraudulent petition with the Chancery Court. To make matters worse, they've ridden this lie out, and they have asserted the entire time the case is closed out with Department of Child Services on what she had tried to claim. Tried to claim that my wife had struck my child, and it never happened. My daughter even told them it didn't happen. And how somebody like this can continue on with their lies and continue to get away with it. I directly hold the state of Mississippi responsible for this, just as much as I hold her. Definitely directly hold her attorney responsible. Her attorney, Mona Pittman, played a significant part in everything that happened back in 2017. Liz and Mona Pittman together. And what you'll find out, and what you'll really start to see in this filing, is that they played an absolutely crucial part. They probably played the biggest part in everything that happened in 2017. And knowing that I'm trying to get myself exonerated, vindicated, and seek justice on the true criminals, of course that doesn't sit well with them, because they know that they're the biggest domino to probably fall in all this. So, I've got this filing. They have no right to get my... it's not like I have anything to hide. They have no right to get it. And it's about precedence. It's about putting my foot down. Because they cannot spawn a false petition, fraudulent petition, and then continue digging new rabbit holes trying to search for something, anything, to help justify their reason for being there in court for making that filing. So here it goes. Comes now before the court, Matthew Reardon, your confused, mentally anguished, and dumbfounded pro se defendant, and hereby with this motion moves this court to quash, suppress, and sanction the petitioner and her legal counsel after their continued insistence, through grabbing at straws one after another, to unfairly berate and overwhelm the defendant by continuing to go down additional avenues or quote-unquote rabbit holes. Defendant states before this court that this is precisely the case yet again, and the motive and reasoning behind the latest move by petitioner and her counsel to subpoena records of the defendant from 4 different law enforcement agencies should make it abundantly clear to this court that the petitioner and her counsel's sole goal at this point is to cause or create unnecessary delay in order to further harass and victimize the defendant on matters that the plaintiff and her counsel knowingly caused and or played a significant part in creating. There are several major issues at hand now, and this court has been made complete aware of in prior filings and motions, including, among others, the petitioner's attorney knowingly defrauding this court, as well as the defendant, through her filing of a fraudulent petition in which the notarized affidavit was duplicated and further used twice. The September 30th, 2020 petition filed by the petitioner attested to August 26, 2020, which was the original petition filed. The notary attested to the document from August 26, 2020, not from September 30th, 2020. This amounts to an incurable error, one that cannot be characterized as being a clerical error. This also happens to be one of very serious nature because of the liability that such careless and negligent actions pose on the notary public herself. Petitioner's attorney even had the audacity to not even so much as issue a response in the 10-day window allotted for response, further showing the willful and intentional efforts to write it out and to take it further by poking and prodding in other areas of the defendant's life, which not only she is not privy to, but she had no reason to ascertain based on the original petition that's been filed with this court. After all, this cause stems from petitioner's attempt to reduce even further the defendant's visitation with his minor child, whom he has demonstrated the highest levels of care for, and a psychological report from September of 2017 speaks to the professional opinion of such. This court has an obligation to look out for the best interest of the minor child and defendant asserts the most prejudicial of treatment counter to the obligation a family court is expected to provide. It is for these reasons that defendant moves this court to quash, suppress, strike, and sanction the petitioner and her legal counsel for their knowingly unethical and unscrupulous actions in trying to further tear down an innocent man, father, patriot, and veteran, whom for the entire time has clearly sought out equal protections of state and federal laws. The highest levels of care, despite petitioner's repetitive lies and false allegations on the defendant. Defendant has stated numerous times now in this cause that petitioners had a history of making false reports and that retaliation resulting from her being picked up on a warrant cut by Olive Branch Police Departments and stemmed what all signs now show to be another witch hunt of the respondent, combined with the systemic kidnapping of the defendant's minor child for the past year. That petitioner went in gross contempt of this court's visitation agreement. Petitioners continued to bite the hand that feeds her through the perpetuation of libelous, defaming, and dangerous lies that are now clearly insistent upon the initiation of additional proceedings outside of this court, and Movant states most certainly warrants a criminal investigation due to the continued commission of crimes which have been directed at the Movant. While this constitutional crisis stemmed from the petitioner and her counsel along with the assistance of certain other John and Jane Does to be listed, it is the absolutely bizarre handling of this matter by local agencies and even the courts that have exacerbated this issue to it now being one that, quite frankly, has grown to levels the Movant never imagined he would see. Not immediately rebuking and condemning this sort of behavior and allowing petitioner to steadily play her guessing game and fishing for something to hang over the Movant's head has now taken on the face of fully condoning this type of despicable behavior. Sadly enough, it doesn't stop there, as the Lafayette County Sheriff's Department and Olive Branch Municipal Court have even gone so far as to target and even arrest the Movant, once again a USMC veteran, for seeking out protections of the laws in his full expectation to be afforded equal protections of the law under the laws of Mississippi, further outlined in Article 3 of the Mississippi Constitution and concreted absolute by way of the 14th Amendment of the United States Constitution, which Movant feels has been completely decimated over the past few months through the completely jaw-dropping criminal acts and the acts of condoning. Movant would assert an absolute necessity for a racketeering probe to take place and for the proper authorities to immediately intervene without delay in order to halt and deter the level of criminal conduct that mimics the exact same criminal conduct aggrieved in May of 2017, which Movant has gathered all evidence to prove beyond all reasonable doubt was a staged crime that never actually occurred, in order to silence, disarm, and get rid of the Movant due to the civil and criminal liability that certain private individuals, along with elected officials and government employees, directly brought about due to their malice choices and acts. The petitioner and her attorney, Mona Pittman, are in fact two of the most guiltiest of parties due to the extensive part they played in everything, which is why the petitioner's attorney went to the extent she went back in 2017 to shield herself, even though Movent has not had any contact with her outside of serving her a response to a court filing on May 8, 2017, which there is video evidence of. Movent puts Lafayette County and the state of Mississippi on notice of its grievous violations of not only its own state constitution and laws, but federal laws through intentional violation of 42 U.S. Code 1985, 42 U.S. Code 1983, and have flagrantly denied Movent the equal protections under state and federal laws, a key component of the 14th Amendment of the United States Constitution. Previous notices of violation have been issued by Movent, and the same criminal conduct involving knowingly false accusations alleged by the petitioner in this cause over the last 3.5 years continue. It is blatantly clear to see the end goal is exactly what Movent has asserted since May of 2017, that Movent's child has been used as a manipulation tool by her mother at the disposal of the defendant and through the help of agencies and courts.